lawyers have a unique way of thinking. It involves more than just memorizing laws. Thinking like a lawyer requires a particular approach to problem-solving, analysis, and advocacy. This ability to think like a lawyer is not innate. It is gained from years of legal training and experience. In fact, lawyers are taught from day one at law school to think critically and strategically, to dissect complex situations a client may face, to remain professional, and to prepare compelling arguments. So whether you aspire to become a lawyer, are currently studying law, or simply want to enhance your analytical thinking skills, the principles discussed here will prove invaluable, not just in the courtroom, but in life. In this post, I explore 3 key ways lawyers think: IRAC, ABC, and the importance of passionate and zealous advocacy. One of the most fundamental tools in a lawyer's arsenal is the IRAC method. It is one of the first concepts that is taught in law school. This acronym stands for Issue, Rule, Application, and Conclusion, a structured framework for analyzing a complex set of facts and legal problems to produce a well-thought-out, logical, and persuasive answer. IRAC is used in any given case and problem the lawyer is presented with, whether from a client who complains about their ex, or a client who angrily talks about a police encounter, to a business client who is focused on making profit. These conversations can become aimless without the lawyer's gentle but firm direction and guidance. The first step in IRAC is about identifying exactly what the relevant issues the client faces, and to pinpoint the specific legal questions to answer and advise the client upon. The issues could be about the various disputes between the parties. For example, whether the client has a right to see the children because their ex is preventing access. Those issues could also be about specific points to be resolved. For example, whether the police use of handcuffs during the stop was lawful. Or, those issues could be about the practical legal support to be provided to the client to advance their objectives. For example, what to include in a planning application to strengthen its chances of success to set up a restaurant in a busy residential area. The lawyer's mind, often presented with a mass of information from their client, works out what all the relevant legal issues are that require addressing with the client. Moreover, the lawyer is also trained to focus on what does and does not matter, ignoring the emotions, distractions, deflections, misinformation, and the red herrings from the client's account and predicament. But the lawyer does more than this. They proceed to prioritize all those identified legal issues in a logical order of importance to systematically address. And with each issue made clear and with the client's overall objective in mind, the next step is to determine the relevant rule or legal principle that applies to that particular issue. This rule could be a statute, a case precedent, or a legal doctrine. This rule could also be a judicial comment or an established academic expert's researched opinion. The lawyer certainly does not answer questions a client may face with reference to an unsound opinion from an encyclopedia, or a legal definition given in a dictionary, or with reference from comments made by a social media influencer. So, for example, a lawyer will refer the family client to the relevant family laws on access to children, or refer the citizen client to the relevant established legal principles of legitimacy, necessity, proportionality, and justification concerning the police use of force, or refer the business client to the relevant planning laws and building regulations about setting up a food outlet in a particular area. With the rule in hand, the next step is application, connecting the relevant facts of the case to the rule or legal principles. This important step involves reviewing and analyzing all available information, including from the client's instructions, the evidence, and the legal landscape, and then drawing out the key facts and applying them to the rule. Application can also involve considering how the rule applies from different perspectives, those facts that support their client and those facts that support their client's opponent. In this way, the lawyer is also able to help their client identify the strengths and weaknesses of their case and the strengths and weaknesses of their opposition's case, or to know the possible obstacles to a successful outcome. The C in the IRAC way of lawyerly thinking is the concluding point on the particular issue, a clear and concise answer to the specific legal issue addressed. For example, the concluding point could be the client has a right to see their child, or the police used unlawful force in the encounter, or the concluding point could be the inclusion of a road impact report would strengthen the planning application, and sometimes the concluding point could even be that more information is required to determine the issue. And finally, the IRAC analysis culminates in an overall conclusion. This may take the form of advice, recommendation, or solution to all the legal issues the client faces, supported by all the reasoning presented. For example, the overall conclusion could be the family law client is entitled to half the household assets and a right to see their child. Or the citizen client has a good case to sue the police for compensation because the police actions amounted to an assault, or the business client is likely to succeed in their planning application. The IRAC method is indeed a powerful tool for organizing thoughts not just for the lawyer, but for their client, structuring arguments, and ensuring that legal analysis is comprehensive and persuasive. The IRAC method of thinking also provides a roadmap for the lawyer and their client in any meeting to navigate the complexities of the problem at hand to arrive at a well-reasoned conclusion. In addition to IRAC, lawyers often rely on another important way of legal thinking, ABC: assume nothing, believe nobody, confirm everything. This mantra, borrowed from law enforcement and investigation, in legal practice, underscores the importance of skepticism, thoroughness, and independent verification, especially in contentious civil or criminal cases. Assume nothing means approaching each case with a fresh perspective, avoiding preconceived notions, stereotypes, or biases. It requires questioning assumptions, digging deeper into the facts, and considering all possible angles. In practice, it means dealing with each case on its own facts and not jumping to conclusions. For example, thinking the family law client is unreasonable simply because they are a man, or believing a criminal client is guilty just by the way they look, or assuming the business client has the fees to pay because they want to set up a multi-million-pound business. Believe nobody emphasizes the need for independent verification. Lawyers cannot simply accept statements at face value from an opposing advocate, police officer, expert witness, or even from their own client. Finally, confirm everything underscores the importance of due diligence. Lawyers must verify every detail and cross-check every information. They must corroborate information through evidence, witness testimonies, CCTV, and their own commissioned expert to ensure that their arguments are built on a solid foundation of confirmed evidence. While the ABC method of thinking may seem cynical, it is essential for ensuring accuracy, fairness, and yes, justice. By questioning assumptions, verifying information, and leaving no stone unturned, the lawyer who employs the ABC method of thinking has uncovered serious miscarriages of justice, found the truth, and protected their client from further time behind bars. The last way outlined in this post, and probably the most important for a client concerning how a lawyer thinks, is also at the heart of advocacy, passion, and zeal. Beyond the cold analytical skills of IRAC, or the meticulous attention to detail using the ABC skill of thinking, effective lawyering requires something more, much more, passion and zeal, without which the client is left unimpressed and uninspired by their lawyer. These two qualities fuel the lawyer's commitment to fighting, both privately and publicly, for their client's rights in pursuit of justice. Passion, in this legal context, refers to a deep-seated belief in the cause and the client you, as the lawyer, are representing. It is the inner driving force that motivates great lawyers to work tirelessly, overcome any and all obstacles to protect, advance, and advocate fiercely for their client. It will push a lawyer to seek undisclosed evidence like phone records, or to cross the world to find supporting witnesses for their client's case. Zeal, on the other hand, is the outward expression of that passion. It is the demonstration and show of energy and enthusiasm, and the unwavering dedication that lawyers bring to the trial, the negotiation, and every aspect of their work. Passionate and zealous advocacy is not about aggression or winning at all costs. It is about using every legal tool and strategy available to achieve the best possible outcome for their client, while upholding the highest ethical standards. Where passion exerts every sinew in the lawyer to work hard, zeal pushes the lawyer to step out from the shadows to perform on the stage, whether it be in a police interview, courtroom, or around a negotiating table, and become the superhero for their client. Passion and zeal are not merely desirable traits in a lawyer, they are essential for effective representation. They inspire confidence in clients, command respect from adversaries, and ultimately contribute to a more just and equitable legal system. In the end, there are many ways to think like a lawyer. But as a beginner, if you want to think like a lawyer, think IRAC, think ABC, and think about the belief and skill behind the passionate and zealous advocate. And by adopting these lawyerly mindsets, you too can also approach any challenges with greater clarity, precision, and effectiveness in court or in life. Thank you for watching. Feel free to comment and subscribe to Community Legal Education for more.